during the 2020 elections. So as we prepare to witness what will happen in court today, what are some presentations? We are getting indications that the petitioner's third witness, in the person of Mr.
consideration to the other parties.
Honorable, without seeking to preempt what will happen in court today, will allow you to go so that when sitting is over, we may be able to analyze whatever transpired in court. Thank you very much. And that was Honorable Joyce Mutari. She was former Minister for Transport, also spokesperson for so far in the 2020 election petition, no issues of contempt have come up. Yet, I'm sure many persons in the petitioner and especially also the second respondents probably have taken a cue from what happened in 2013. Has not addressed the media. In his place, the Minister Designate for Information, Honorable Kujo Oponkoma, has been the one addressing the media, supported by Nana Boache, who is also a lawyer and currently on the Chief Executives of the National Service Scheme. So we are waiting for the arrival of some of the key petitioner's third witness will be in the box. But arriving right now is the chairperson, the chairman of the National Democratic Congress, the NDC's national chairman, has arrived in the company of Mr. Sylvester Mensah. You would recall that Mr. Sylvester Mensah was one of those who representatives of the NDC's presidential candidate at the EC's National Collation Center, which is often called the Strong Room, Mr. Rojo Metonunu, and again, Mr. Gabriel Asari Ochridako is one of the leading members of the MPP, and he's also a lawyer as well. Thank you very much. Without attempting to preempt what is likely to happen in court today, the last time the court sat, indeed, there was, they met in chambers. Of late has been addressing the media on behalf of the second respondent's legal team. That is after the court singled out Mr. Frank Davis and instructed him to desist from granting media interviews. Again, we have the legal persons making their entry to the Supreme Court. We wish you good luck, sir. And I'm still here with my colleague Barbara Kuma as we attempt to put all of this in perspective for you, viewer out about events of Wednesday, application to and also for the petition. This case that according to the counsels for the second and first respondents, I mean, it was not the proper timing. The timing was wrong for them to even be asking. Way back into time. So why are we here to start with once again? At the time began to have issues, and there were protests nationwide against the ECs and the declaration of the EC's results and so on, and following that we are here, and good. So we now see members of the legal team of the second respondent making their way to court right now. In 2013, the lead counsel for Nanado, who was then the petitioner, was Mr. Philip Addison. Of course, Mr. Philip Addison is not part of this team this year. So there are the members of the legal team. Two of them actually, they are four in number. The two lawyer Alphonse here, and then Mr. Frank Davis as well, making their way to now. Because all of us set for hearing this morning. Immediately after the declarations, but then on the 30th of December 2020, former President John Mahama filed the case in court. And since then, we've had the first day hearing began. It had to do with an application, and we've seen several applications from the petitioner's side. The first application was even before the court sat, which sought for some amendments in their original petition. You recall?
Yes, I do recall. Well, there were some small mistakes, error, if I should say, on the petition that was filed by the petitioner, that is the former president. So he applied to the court as and when there's fresh and breaking news from the Supreme Court. Otherwise, continue to stay with us here, even as we continue educating you and informing you as well.
Lords, Rate number J1/5/2021. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adodankwa Akufo-Addo. John Dramani Mahama, please. Johnson, I see you doing Ketia, my Lord. It's representing the petitioner. My Lord. Jane Mesa, chairperson, is representing the first respondent. Mr. Peter McMahon is representing the second respondent.
Your Lordships, please, I appear for the petitioner, and with me, my learned friend, Tony Lither. May it please my Lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somwa Samoa.
Pleases your Lordships. Kotuampa appears for the second respondent. My Lords, with me are my learned colleagues Frank Davis, Kweku Esrefi, and Yao Feng.
Lords, our next witness is Mr. Robert Joseph Meselnuno, and he is appearing remotely, and I believe he can be connected.
I wish to raise a number of issues for consideration before we address the matter of the witness statement. My Lords, my first concern is whether we have a judicial officer where the witness will be testifying from, so that we are certain that there's nobody or no means of prompting him when questions are asked. Because this is very important in our view.
We discussed in detail the modalities for this evidence and the concerns which were raised by counsel on the other side. And you all took it into consideration. So, Mr. Nakotampa, let's move on and do some business.
Since that discussion, in fact, that very day, they wrote waiving those confidential matters.
Yes.
And therefore, we are saying that this is a trial. Normally, even when somebody is giving evidence from abroad, you have an officer present whilst he's giving evidence. I think this is a very fundamental issue I'm raising.
Mr. Kotampa, why didn't you come with the other counsel into chambers to tell us this morning?
My Lords, because we were told that this matter will be discussed, the case is now to be in public. That is why. Otherwise, I would have done that. But I submit that this is a very major concern for the second respondent. We We want to be sure that the witness is not being prompted or given any assistance. And that can only be properly done if there is some oversight by an official of the court.
What's your next concern? You said you had a number.
Yes, my Lord. My next concern is your Lordships will notice from the witness statement and the attached statement of truth that the attached statement of truth reads, I, Robert Joseph Metonunu, say that I am the witness herein and that I made this statement in respect of this presidential election petition, and that to the best of my knowledge and honest belief, paragraphs 1 to 16 of the witness statement are true to the best of my knowledge, information, and belief. Now that means that the witness has only sworn to paragraphs 1 to 16 of the witness statement.
Mr. Kutampa, what are the legal arguments around this?
No, my Lord, I'm coming to the point.
No, Mr. Kutampa, I thought you said you had some preliminary matters.
Yes.
No, wait. Now, I think this you raise when an attempt is made to put the statement into the proceedings. So we take the preliminary ones. This relates to the statement itself.
Very well. Available to your Lordship's guidance.
With the first preliminary issue that you raised, I think we can observe his demeanor. I mean, we can observe his demeanor if somebody is talking to him or passing the document to him. We can observe from the screen. So I don't think.
My Lord, can I be of assistance to the court? My Lord, may I be of assistance to the court? My Lord, we are completely in agreement with the principle that a judicial officer can be in attendance. We have absolutely no problem about that. And my Lord,
Peter, can you speak into the microphone?
I'm sorry.
Otherwise, we lose the record.
In terms of that principle, it's very clear. We are not in objection. So it should take perhaps not more than 25 minutes to have a judicial officer present at the location where he is to allay the fears. So respectfully, my lords, if a judicial officer can be designated, that judicial officer can go to the venue, which, you know, I mean, that should not be a problem.
Would it be safe? How proximate can this judicial officer get?
Oh,
What you have told us.
My lord, in fact, I'm certain there's actually a medical officer also in attendance at the location. So I'm sure that he can have a discussion with our medical officer in terms of the issues that your lordship is addressing. I'm pretty certain about that. The medical officer has provided a letter also to the court, and I believe that he can address that issue. Currently, according to the review from the day that your lordship's granted us indulgence, that issue really does not arise currently. But the judicial officer probably can actually be in the room, because I think, as far as I recall about the judicial officer can just go there, and in conjunction with both the medical officer and
Please, we will adjourn for 30 minutes and consider this. No, you will send somebody. Yes. Okay. Yes, we will arrange with you through the registrar. Yeah, okay.
Stop. All rise.
Many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Fully committed to being fair and impartial.
Current affairs.
The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us.
The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Zungu community not to have education.
The show is the sea.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television, Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limits.
Economy. Politics. Sanitation. Agriculture. Education. Join me Monday to Friday as we dialogue on issue-based politics. Live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV. Net2 Television. Beyond the limits.
Allahu Akbar, Allah.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Jama'a bayin Allah masu kallon mu ni ne naku Abu Karim. Alhamdulillah. Lokaci ya kai zamu so mu kawo muku shirye-shirye a nan television Net2 in Allah ya yarda. Nan muna so mu gane wane ne Allah subhanahu wa ta'ala. Bayan wannan kuma mu gane menene Qur'an. Bayan wannan kuma muna so mu gane wane ne Annabi Muhammad sallallahu alaihi wasallam. Bayan wannan kuma mun duba yaya za a yi in yi so yaranmu su gane Qur'ani. Bayan wannan kuma mun kawo muku shani siyasa. Bayan wannan kuma mu kawo muku batun abincin gargajiya na zango yanda za a yi mu gane zama cikin zango in yi so zamantattayyarmu ya yi kyau cikin zango. Ni ne naku Abu Karim. Wassalamu alaikum.
Watch Asrats every Wednesday 6 p.m. to 7 p.m. Repeats Thursday 6 p.m. to 7 p.m. only on Net2 TV. Net2 Television, beyond the limits.
Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television on Mon FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
The economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics. Live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV. Net2 Television. Beyond the limits.
After many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Fully committed to being fair and impartial.
Current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Zumbu community not to have education.
The show is the seed.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limit.
Learning to read, reading to learn, learning to read, reading to learn.
Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation.
Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn.
Susu.
Susu. This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.
I believe the registrar will swear.
So, alright. We ask your permission to swear the witness. So, this is the Bible. Lift it up and say after. Say, I, listen with it, please. Robert Joseph Ethel Nunu, do swear on this Bible. Do swear on this Bible that the evidence I will give this case. That's the evidence I will give in this case. Shall be the truth. Shall be the truth. The whole truth. The whole truth. And nothing but the truth. And nothing but the truth. So help me God. So help me God. I was SOB in English.
Can you give your full name to the court? Can you give your full name to the court? Have you unmuted? Have you unmuted?
Can you hear me?
Yes, now we can. Yes, please give your full name to the court.
My name is Robert Joseph Ethel Nunu.
Now, you have put in a witness statement in respect of this case. Is that right?
My Lord, that is correct.
My Lord, may we have the witness statement adopted in these proceedings. And do you have a copy of that witness statement with you?
Yes, my Lord, I have a copy of the witness statement.
Very well.
My Lord, we wish to draw the court's attention to the fact that
Yes, my Lord.
Yes, do you have any objection or comments or whatever?
No, for now,
okay.
I will abide by my learned colleagues' submissions.
Yes, my Lord. The witness statement has a statement of truth attached to it. And my Lord will see when I read, I, Robert Joseph Metonunu, say that I am the witness herein and that I made this statement in respect of this presidential election petition, and that to the best of my knowledge and honest belief, paragraphs 1 to 16 of the witness statement is that true to the best of my knowledge, information, and belief. My Lord,
that on the face of this document means that the witness is swearing to only 16 paragraphs of the witness statement. We would submit that paragraph 17 to 32 should be struck out as not part of his witness statement. My Lord, this is a very important issue, because in our view, this witness statement and the truth, the statement of truth, show that the witness statement was first crafted up to 16. And it is only after the cross-examination of Professor White and the rest that these other 16 paragraphs have been added there.
When did Dr. Professor White leave the witness box?
He left the witness box on
Wednesday.
Wednesday, yes.
Mr. Kutamba.
No. My lords, may I be permitted? No, it isn't.
Speculative.
My lords, if I may be permitted to demonstrate my point. My lords will notice that a letter was written to your lordships that I'm sure we can all take judicial notice of by counsel or solicitor for the petitioner. And if your lordships were to look at that letter, your lordship will notice that the letter was written on the 4th of February. But attached to the letter are two other letters, both dated 3rd of February, the very day that they saw the leave, and gave the impression that the witness was so sick that we needed to have...
Mr. Kotomba, how are we supposed to work with the submissions you're making? How do you corroborate them?
Excuse me?
How do you intend to corroborate the matters you're bringing up? How do we work with these submissions?
My lady, it is a fact that it was on the 13th, it was on the 3rd, that they raised these concerns about... So
your submission is that paragraph 17 upwards should be struck out. Is that your submission?
Yes. And I'm trying to explain that this is not just a typo error. It is indicative.
What you are saying is very speculative.
No.
You made a point that the statement of truth admits only up to paragraph 16. But it is clear from the document that he has signed after paragraph 32. So whether the paragraph 17 to 32 was added after Dr. Professor White's evidence or not, it's neither here nor there. The point is that the statement of truth says that he verifies paragraph 1 to 16.
Yes.
That is the point.
Yes.
Yeah. So I think that should be it.
Very well.
My lords, unfortunately, I do have to make reference to certain comments that my learned friend made, because not only are they speculative, but with respect, they cast aspersions onto my integrity. I did indicate that there was a medical review on that day. I did give that indication, even whilst we were in court. And I indicated that I would be in contact with both the medical official as well as the witness. I believe those were clear indications, and I did that in the morning before your lordship. So for it to be suggested that somehow some things have been done, you know, I think is really not just unfortunate, but I really do not expect that we should get to this kind of depth. My lords, we took the liberty of notifying them as soon as we came to court that day that this is a situation. And we gave the facts. So, my lords, I do not think that my learned friend should be entitled to make these aspersions.
We've stopped him. Yes, because we thought that when counsel on both sides maybe give concessions, the court should take it as coming from honorable men at the bar. So please, let's go on. Let's go on.
So, my lords, we are at the point of having the document adopted. He's raising an objection. Very well. So, my lords, may I respond to that objection? My lords, respectfully, that objection is without a basis. Because the witness has put his signature under the 32 paragraphs. And my lords, the witness that is actually the only place on the document where the witness has signed. Now, my lords, the witness can himself explain, and I do not wish to anticipate, but the witness can, I'm sure, explain whatever is needed to be explained in relation to this document. I do not want to provide any. I'm not going to say that.
My lords, I'm happy that counsel is saying that the witness himself can explain, which is to say he doesn't have a response to my objection. And it is not for the witness to explain at this time. The witness, but that is
Mr. Kusampo,
yes,
if you look at CI 87, the rules are very broad. From 3E to 3F, the rules are very broad. He does not need to be confined to his witness, even to the witness statement. So I think that you should look at the rules.
My lady, I didn't get that. You see, one doesn't need to be confined to the witness statement. Is that what you are saying?
Kindly look at CI 87 from 3E down. The role of the witness statement. Yes.
Yes. Yes. My lord, but our point here is that there's no good reason. There's absolutely no good reason. You can't swear to a 2-paragraph witness statement and say that you are swearing to the truth of the first 16. It shows that there's a real problem, because it's not as if he said he was swearing to.
You want a ruling?
Yes, my lord.
I think the way forward, can we suggest that you apply to amend the statement of truth?
My lord, respectfully, I would have done that. I did not want to preempt, because the witness actually has drawn my attention to certain matters, not only in relation to that part, but in relation to a couple of other, where instead of 2020, it's 2021 and so on. He's drawn my attention to it, but I did not want to be the one to say that. I think, respectfully,
in evidence.
Yes, my Lord, the document is in evidence, but my Lord will see that the statement of truth is not a statement that he has signed to, but it is after his signature. Yes. And that is why I thought that, given the opportunity, the witness himself can, address, because as I said, my Lord, I can say from the bar respectfully that he actually drew my own attention to it. I myself had not, he drew my attention to the fact that...
As counsel, can't you
very well, my Lord,
amend it so that we can make progress?
My lords, may I respectfully apply to have the paragraphs 1 to 16 indicated under the witness's signature to read paragraphs 1 to 32. The statement of truth is in respect of the whole of the witness statement. And the whole of the witness statement has 32 paragraphs. There's absolutely no basis for insinuations about...
The basis, Mr. Chikata, that is a document you brought to us.
Okay,
there is a basis. You know there is a basis. This is what you brought to us. So he could have let it go, but he didn't let it go. But
and let's move on.
My lords, very well.
By court, leave is granted for the amendment sought. Let the statement of truth cover paragraphs 1 to 32 inclusive. That's all.
We're most grateful, my lords.
Yes, my lords, we will pray to have certain paragraphs in the witness statement struck out. On the grounds that we are not supported by the pleadings. Also, on the further ground, my lords, we are referring to part of paragraph 4, starting prior to the so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duties she was supposed to perform in order to be able to declare a winner of the election, as she attempted to do. In the entire period after the election on 7th December, she made a couple of very brief visits to the strong room.
Line 3.
Yes, my lady.
Prior to. Prior to.
Prior to.
The end.
Yes. My Lord, no. Paragraph 5.
No. And your reason for contempt
is that it is not borne out of the pleadings, my Lord.
Yes.
My Lord, paragraph 5. We pray to be struck out as not based on the pleadings. My Lord's paragraph 6. We pray should be struck out. Again, it's not borne out from the pleadings. And these are material allegations of fact that if they intended to rely on, they should have pleaded. My Lords, paragraph 7 is equally not borne out of the pleadings. My Lords, these are very serious material allegations of fact. And if they wish to rely upon it, they should have pleaded same. These are basic rules. To borrow my learned counsel on the other side, they are elementary rules of pleading. My Lords, again, my Lords, paragraph 8. It's not based on the pleadings. And we pray that it be struck out as such. My Lords, Your Lordship have ruled on the question of authenticity in respect of the attempt to seek originals. And our objection on that issue was that they had never in their pleadings raised issues of authenticity, which are very serious matters. But following the court's ruling, they are seeking to introduce authenticity issues through the back door. They should not be permitted to do so. Paragraph 9, my Lords. My Lords, may I proceed?
Can we be clear if the objection is to a part or because he's generally given us a portion of the paragraph? So just to be clear whether it's the whole or...
That paragraph can only be understood as a whole. So as a whole should go. Nothing should be left out. My lords, we again object to paragraph 10 as a material statement of fact, not found anywhere in their pleading. It is an attempt, like the earlier ones, to build a new case after the event, after the cross-examination of the first and second witness. My lords, this convenient excuse of the witness being misled is nowhere in the pleading.
To paragraph 11?
Yes.
Or what?
That's not 11 I'm speaking about. Paragraph 11, where the witness claims, I admit I was misled.
So are you objecting to paragraph 11?
That is so.
Okay, you had not stated so. You had not stated so.
I'm sorry. We are objecting to paragraph 11 on the grounds that it is not grounded on the pleadings. My lords, it is our view that paragraph 12 should be struck out as an opinion. We don't plead opinions, we plead facts. Sorry. My lords, this is evidence. And the evidence here
Mr. Kutampa.
Yes, ma'am.
You mentioned that you're objecting to 7 paragraphs out of the 32.
Never, my lords. I think
you mentioned 7.
I mentioned no number.
I'm sorry.
No, my lord.
Okay.
I said certain. Very well, my lords. My lord, paragraph 15. The portion that reads, both could not be authentic. Only by getting the originals of these documents can there be clarity on exactly which is the genuine form from the region. My lords, this is again an attempt to slip through the back door. The question of production of original documents. An attempt to which the court firmly closed its door.
Yes.
My lady, my lords, paragraph 16. Is not to be found in their pleadings. Let's refer to paragraph 17. It is our view that it is not pleaded. It should be struck out.
Mr. Angutuampa, yes. Are you saying it is not based on the pleading or the petition?
It is not.
Or you are not? Or you are saying it is not in it? It is not based on it.
It's not based on it. My lords, paragraph 18 raises once more the rather infamous question of authenticity and the need to produce the originals. My lords, this whole issue of consultation, paragraph 32.
You are seeking to attack paragraph 30.
Yes, paragraph 30. My lords, no. Yes. My lords, I believe I've dealt with paragraph 18.
Yes, you have been recorded. Yes, you've been recorded. You are saying that he seeks to introduce the originals. Sorry, the issue of authenticity. Yes, through the back door.
Yes. My lords, paragraph 19. This is a story about making an error when he signed. And Lord, it's not based on the pleadings.
So if the man wants to say I made a mistake, he shouldn't be allowed to say it.
My Lord, this is a very, very material fact. My Lord, it's a very material fact. Because he had already signed the document. So if he was...
You see, it's not supposed to be under oath to be examined.
My Lord, I'm saying that before we...
No, I'm asking you a question.
Yes. But before he's cross-examined, we must make sure that the evidence that is given is supported by the pleadings, insofar as it relates to material facts. Insofar as it relates to material facts. And it is our submission that this allegation is an extremely material matter, and they ought to have pleaded it. My lords, it applies equally to paragraph 20. My lords. My lords, we pray that paragraph 22 Yes.
What is your submission of paragraph?
Oh, I see. My lords, paragraph 22 is directly connected with 21. It's only a further elaboration of
objection to
paragraph 20. 20, yes.
20.
Yes.
The basis for the objection. I'm recording you.
My lords, it's our case that, again, this is a very material allegation of fact, and it should have been pleaded, because they are seeking to build their case on it. Should have been pleaded. Nowhere in the petitioner's initial petition nor its amended petition do we find any reference to this material factual allegation. My lords, we refer to paragraph 22 and say that this is not based on their pleadings. Indeed, their pleadings refer to the letter that they wrote to the EC chair. And according to them, the EC chair ignored them or did not respond to their concerns. There's nothing in the pleading about this very important allegation of fact. If they were ready to attach a letter they had written to the EC chair as part of their petition, it beggars belief that these very serious allegations of fact against the EC chair was not pleaded. This is in relation to paragraph 22, my lord. It says that he sought to consult with the chairperson of the EC. I also needed to receive feedbacks on the concerns I conveyed to her the previous day.
Seem to be relating it to a letter.
Yes.
But there's no relationship.
No, there's no relationship, my lord. But my point is, if they found it important a fact to plead, about the letter. This serious allegation of fact should have been part of their. It's not pleaded.
There's no foundation in the pleadings, or it is not
no basis.
Because there's a sharp distinction between
my Lord,
evidence and material facts.
I'm very well aware of that.
Yes.
So I'm sorry. I'm sorry that I said it's not based on the pleadings. My Lord, the paragraph 23 is equally not based on petitioners. Yes, my Lord, pleading. My Lord, we object to paragraph 24 for the same reason. 24, my Lord, that it is not based on the pleadings. These allegations of deceit, they should have made the allegation and even given particulars of same in their pleadings, in accordance with the rules CI 47.
Is it the entire paragraph or a part of it?
My Lord, we would pray that the entire paragraph be struck out.
And where does the paragraph talk about deceit?
My Lord, it reads, there was nothing in the discussions which could have given me any reason for doubting the word of the chairperson of the EC.
But it doesn't say she deceived him.
But my Lord, if you go into the next paragraph, it shows that the allegation is that they let the chairperson send them on this.
Your submission was that it's an allegation of deceit and particulars of it should have been given in pleadings. And I'm saying that I don't see any reference to deceit. He said, I had no reason to doubt her word. Is that an expression that she's deceived him?
My Lord, see, if your Lordship, with respect, will refer to paragraph 29. No, but my Lord, they are connected.
Unless,
my Lord,
oh, please, counsel, is it not a practice that if a judge is speaking, counsel should keep quiet?
Well, no,
unless you want us to read it in conjunction with that paragraph. Yes. We are not doing that.
Now, my Lord, it is our submission that some of the paragraphs cannot be understood standing alone by themselves.
Yes, you are on your feet. Yes, you are on your feet.
But my Lord, that's precisely what I was doing.
Dr. Tampo, are you suggesting that we should read paragraph 24 together with paragraph 29?
Yes, my Lord, together with paragraphs 29 and 30 and 31. It's very clear.
I think that 24 stands on its own, so anyway, go on.
you read these paragraphs together, the allegation is very clear that the EC chair deliberately led them on a wild goose chase in order to declare the results in their absence. That is the gravamen of those paragraphs. And my lords, I'm saying that these are very material allegations. And they ought to have pleaded, and the particulars of which given.
Under paragraphs 24 and 29.
That's an allegation of a state of mind, an act by the chairperson with an intent, and he ought to have given the particulars of that intent to mislead in their pleadings. My lords, if your lordships do agree with us, then it is our submission that paragraphs 25, 26, would become irrelevant and would have to be struck out as such. Lords, we've already spoken about 30 and 28.
28?
No, 29, my lords. Yeah. 20 and 29. 29 and 30, yeah. My lords, 31, in our view, follows accordingly. It's the same narrative of having been misled and how he couldn't believe that the chairperson could do that. My lords, that is all. Yes.
You mean what you can't believe is also part of your objections?
Excuse me?
What he cannot believe is also part of your objections. 31.
Yes, by saying that 31 is part of that set of paragraphs that are speaking to the question of deceit and being misled. A deliberate attempt to mislead them. That's... Yes. 31, my lords, reads, I can still not believe she did what she did in the light of my experience. So is talking about what she did. That is misleading her. That's the fundamental, that is the sentence. The other things are what we call adjectival clauses in English language structure. The main sentence is, I can still not believe she did what she did. That is the sentence. And then in the light is just qualifying.
Nothing less to strike out paragraph 31.
Because, my lords, it is not based on the pleadings and partakes of the same problem that 24, 29, and 30 have. So, my lords, we accordingly pray that all these paragraphs be struck out.
Mr. Agudompa, in view of, can you correct me, agree with me if I'm right. So, apart from paragraphs 1, 2, 3, and 32, you are asking us to strike out the entire witness statement. Am I right? That those are the only paragraphs that you are not objecting to?
My lords.
No, I just want, because it's an easier way of understanding it than, yeah. Am I right?
My lord, I just want to be sure that my lord, part of 15, not the whole of 15, we've indicated which part. Also part of 17 should be struck out.
So 15, which part?
15, he says the portion.
Both could not. Right to the end of 15.
Okay.
Paragraph 17, my lords. When the portion beginning, that was one of the things to the end. I've read that already. I just do that. Which paragraph? Which paragraph? Refer to paragraph 4, that the portion you want starts from prior to. I think I've done that.
Yes, you did.
Recap.
Paragraph 3 of paragraph 4, line 3 today.
Very well.
Paragraph 4, line 3 today.
I'm most grateful, lawsuit. And paragraphs don't believe we objected to 14. Paragraph 14. We are not.
No, you didn't. You didn't.
Actually, paragraphs 12, 13, and 14.
Okay.
It did not attack
No, 12 is included. He says, paragraph 12, opinion, not based on facts.
My lords,
Just hurry up.
yes, we didn't take objection to paragraph 14. We didn't. We took objection to part of paragraph 15, beginning both could not be authentic. And we objected to paragraph 16. For paragraph 17, we objected to the portion that reads, that was one. Yes. And 19. Yes. Yes, my Lord. So, that is our prayer, my lords.
Yes, my lords, in support of the submissions of my learned friend, I wish to draw the court's attention to the case of Aboaba versus Additional, 1946, 12 Waka 18 at pages 19 to 20. That is so, my lord. My lords, this is what readily came to mind. With your kind permission, this is what readily came to mind on my screen. My lords, the object of pleadings is to compel the parties to define the issues upon which the case is to be contested and to prevent one party taking the other by surprise by leading evidence or material facts of which the other had no due warning. The penalty for failing to plead a material fact is the exclusion upon objection being taken of evidence to establish it, where evidence which could have been ruled out as inadmissible because it is adduced to prove a material fact which was not pleaded has nevertheless been adduced without objection and is before the judge. Goes on and says the trial judge was bound to take into consideration and the appellant ought not having raised his objection. So, my lords, it is our submission that at this key moment, the objection is timeously raised and it should be considered. My lord, the local authority that also comes to mind is Akufo-Addo versus Catalan. Yes, my lord. Yes, my lord. With respect.
That is our practice, please.
Yes, my lord, I concede. I do concede. I'm sorry, my lord.
Order in court, please.
My lords, I submit that there is no basis for striking out any of the paragraphs in the witness statement, and I will unfortunately have to go one by one, and sometimes the same point will apply, but because we're dealing with specific.
But if some of them can be lumped together and treated together, we would appreciate it, if at all possible.
Very well. I'll do my best. I'll do my best to do that. Unfortunately, each of the parts. But very well. I will do my best to avoid having to go into each of them. But my lords, if we start from the paragraph 4, which is being objected to from the second sentence, prior to her so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duty she was supposed to perform in order to be able to declare a winner of the election as she attempted to do. In the entire period after the election on 7th December 2020, she made a couple of very brief visits to...
So, Mr. Shikata, the failure to perform duty you are complaining about, is it the shortness of her visits? Is it the paucity of visits? Is that what you mean?
No, my lords, it is not the paucity of the visits. It is the content of the visits. And the witness statement addresses the content very clearly. The witness statement is very clear about that. And the witness statement it is not the paucity of the visits. I mean, the witness statement is very clear in the fact that, and if I may,
the petition. Are you referring to the petition?
No, I'm going to refer to
the witness statement.
The witness statement itself.
Their objection is that it's not borne out by the pleadings. It's not borne out from the pleadings.
Yes, but I was coming to that, but I thought you threw in a question about whether it's the brevity of the visits. And I was suggesting in response that the witness statement makes it quite clear that it is not the brevity of the visits. Because in paragraph 27, for instance, paragraph 27 is indicated, in any event, by the time we left the EC premises, the strong room verification process with the chairperson of the EC had not even begun, much less come to an end. All that had happened in the strong room was a series of informal interactions and not the process with the returning officer that is set out in the Constitutional Instrument 127. So that's just a direct response to the question that it is not the brevity of the visits that is the concern of the witness statement.
Mr. Article, you see, yes. I have read the petition again and again, and there's nowhere in the petition where this whole story about the strong room had been pleaded.
My Lord, my Lord, part of the problem is that I was going to go paragraph by paragraph as he did.
Yes.
And then I had a question related to whether the brevity of the visits. And then, so I was going to go paragraph by paragraph in terms of the pleadings. In terms of the paragraph of the pleadings. I was going to do that.
Okay.
My Lord, we'll see that from paragraph 6 of the amended petition of the petitioner. It is indicated as follows: purporting to declare the results, Mrs. Gina Duku, chairperson of first respondent, and the returning officer for the presidential election said, at the end of the transparent, fair, orderly, timely, and peaceful elections, the total. So here is a reference to her own statement about transparency, fairness, orderliness, and so on and so forth. Now, my lord, the petitioner then goes on, after referring to the percentages and so on, the petitioner goes on, and my lord, those references, I just don't want to have to go through all the details.
Please go through them, because I'm really confused.
Very well. Very well. So, after 6,
Mr. Chikata, my mind is on the testimony that she failed to perform her duty in that paragraph 4 that you were referring to. My mind is on that testimony. So you referred to paragraph 6.
Yes. I refer to paragraph 6. And in paragraph 6, my reference is to what was stated about how she made a declaration. And in paragraph 19 is a very direct statement that the first respondent and its chairperson, Mrs. Gina Dukwementa, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Then, 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Gina Dukwementa, acted in flagrant violation of the 1992 Constitution. 21. First respondent and its chairperson, Mrs. Gina Dukwementa, in the conduct of their duties, are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, candidly, and not arbitrarily or capriciously, and to comply with the requirements of law. Now, my lords, if the witness is therefore providing testimony that shows why there has not been compliance with legal requirements, if the witness is providing testimony in respect of that, that cannot be said not to be based on the pleading. More so, where the answer of the first respondent itself puts those matters in issue. First respondent in paragraph 4 of her answer says, first respondent says further that the 7th December 2020 presidential election was regulated by the 4th Republican Constitution 1992 and the Public Election Regulations 2020 CIT. So first respondent is taking issue with the pleading, the allegation that you did not act in accordance with the Constitution and in accordance with your legal obligations. It's taking issue and says not only that they are regulated by these, the Constitution and CI 127, but goes on actually to set out in detail, which I will not get into, but sets out in detail how how the first respondent claims there was compliance. That is the whole essence of what is in paragraph 5. the whole essence of those 4 stages that she describes, particularly paragraph 5, Roman 15 and Roman 16. Paragraph 5, Roman 15 and Roman of her answer. She said the Form 12s are then submitted to the returning officer for the presidential election, chairperson of the first respondent, at the National Collation Center. This is an answer from the first respondent as to what is required to be done. If the witness is giving testimony that shows that that did not happen, my lords, that is obviously based on the pleadings. That testimony of the witness, that what she herself is saying she was required to do, that did not happen. How can that not be based on the pleadings? And my lords, in this court, counsel for both the first respondent and the second respondent have cross-examined extensively previous witnesses as regards the compliance. They have cross-examined extensively themselves. And in their cross-examination, they sought to put it to the witnesses of the petitioner that the chairperson had acted in compliance. That's their case. And my lords, if that is their case, again, our witness is able to answer those matters that they have alluded to. So, my lords, in respect of paragraph 4, there has actually been testimony provided under cross-examination in respect of paragraph 4. So all that was read to you about additional and so on, which are well-known principles, matters have already been put in evidence. Matters have been put in evidence at the instance of both counsel for the respondents regarding what took place before the declaration. In fact, my lords, and my lords, this is very, very critical. Counsel, especially for the first respondent, counsel actually put certain matters of fact to PW2, for instance, regarding that all he had testified to about leaving the premises of the Electoral Commission because they had been requested to do so was not true. And that, I mean, these were very serious matters put to the witness. What he said about the reasons why they left, the fact that they left their bags there, and I mean, they had no reason for leaving the bag. All that was stated in cross-examination to be false. All that. That was the case of the first respondent in cross-examining the witness, that everything he said was false in respect of the reason for leaving the place and so on. Well, how can it not be material in a determination of this case? How can it not be material for a witness who was there and who, in fact, if you like, played the lead role, because she is the one who went up and spoke and so on and so forth? How how can his testimony about those matters on which they have already cross-examined and they have put their case in cross-examination, and your lordships have also had reason, respectfully, to ask questions about those matters. I think your lordships asked questions in respect of Form 13. Your lordships asked questions in respect of why both of them had to go and not just one of them. I mean, evidence has been led in this court, particularly in the cross-examination of counsel for first respondent and counsel for second respondent. So, my lords, if there is testimony being offered which can corroborate the testimony, including, my lord, in that corroboration, as your lordships are well aware, in that corroboration, the witness is seeking to bring in a video recording of a representative of the second respondent in these proceedings, a video recording that he made at the time, contemporaneously, which therefore would actually give, additional third-party corroboration to the evidence that is being led. And my lords, in fact, respectfully, we were actually going to ask your lordship for that video to be played before the cross-examination. But of course, he's raised an objection, and we are dealing with that objection, after which we will do that. But my respectful submission is that where in their own cross-examination issues of the credibility of the witness have been raised, it is really lying ill in their mouth to come now and say to this court that a witness who, by all intents and purposes, is able to provide a corroboration should have the matters of corroboration that he's sworn to in this court, they should just be struck out. My lords, that cannot, with respect, be acceptable. And my lords, while I strive to avoid going paragraph by paragraph, I'm bound to refer to some of the specific paragraphs of this witness statement. The paragraph 5, where they are also seeking to strike out, so I will take the 4 and 5 in effect together. The paragraph 5, where the witness is saying that the EC had a video documentary person recording events in the strong room. And I have no doubt that if that documentary is available in its authentic version, it will confirm what I'm saying in this witness statement about things that occurred in the strong room. So, my lord, what the witness is here saying goes directly to the issue of credibility and the availability of information, even in the custody of the first respondent, which can put the matter to rest completely in terms of the corroboration issue. So my lords, how can it not be? I mean, so the paragraph is basically saying to this honorable court, there is a video recording that was taking place. I'm giving you my account. If you have any reason to question any part of my account of what happened, there is a video recording. So the court itself can independently even order that video recording be produced, because we have, issues of credibility arising which we want to deal with. And it is my respectful submission that there can be nothing whatsoever in a witness seeking to underline the credibility of his testimony by making reference to an independent and available source of verification.
Secretary, I agree with you on the principle, but you know, this is a civil trial, and it is based on the pleadings.
Yes.
And the paragraph 5 of the witness statement, now coming to talk about a video documentary.
Now coming to
talking about video documentary.
Yes.
This is the first time we are seeing this.
Yes, but my lord,
the person is not a party. Mr. Nunumetel is not a party, he's a witness. So his evidence must take the form of the petition. The party himself, the petition is the claim before us. So he cannot come and introduce new facts.
My lord,
that the petitioner did not even raise in the petition.
My lord, with the greatest respect,
these are material facts.
My lord,
it's taking us by surprise.
My lord, it cannot take the first respondent by surprise. It cannot take the respondent by surprise because the respondents were the ones seeking to cross-examine, contesting the accounts that had been given by other witnesses, especially PW2. They were contesting it. And what this witness is saying is that if you doubt my story, there is I observed that there was a video recording taking place. So that video recording can be resorted to by this court. Now, this court seeks to establish the truth of what different parties are putting before it.
The rules.
Yes, and the rules allow this court. The rules allow this court to have that independent source of corroboration, to have it available. The rules certainly allow that. The rules certainly allow that. And if witnesses of the petitioner are being confronted with allegations that what they have come to this court to establish is untruthful, and there is a video, for instance, that supports them. In this case, there is a video of Mr. McMahon, which he is seeking to put in evidence. There is a video coming from the EC itself, the first respondent. My lord, I mean, it certainly is important for this court to consider. And my lord,
the video documentary in paragraph 5 is not what has been attached. It's not the video recording of whatever took place with Mr. McMahon.
I'm sorry.
Paragraph 5, yes. The video documentary there is not referring to the video.
Yes, but PW2 also testified to that video. It's in the witness statement of PW2. He testified to that video.
So you're in essence setting up a situation where you can ask for that video then? Is that what you're doing?
My lords, we are not necessarily going to ask for that video. What we are saying, we're not necessarily, my lord, it depends on the cross-examination, because if the cross-examination, and that I believe is why it is very critical that the witness has indicated that there was that video recording, similar to what PW2 also stated. So both of them have said, we are willing to have our credibility put on the line by reference to a video that captured what happened in the same way as the video of what second respondent's representative has said. So there is already testimony before this court. And my lord, I emphasize that testimony came in under cross-examination, challenging the account. So second witness, PW2, said there was somebody taking video documentaries and so on. That evidence was not objected to. That evidence is before you. That evidence was not objected to, it is before you. And we are respectfully submitting that what is stated in paragraph 5 is no different from evidence that is already before you about the video documentary. And all that this witness is adding is that he is willing to put his credibility on the line. So that if anybody wants to have recourse to that video, they're entitled to. Now, my lord, depending on the cross-examination, we may indeed come before your lordship with an application that that video should be produced to the court and played, depending on the cross-examination. Because, my lord, we're dealing with a situation here where matters have been put to a witness in cross-examination extensively, and he has insisted, I'm telling the truth, this and that. And he said, there was this video. This witness also comes before you and says, there is a video. What I'm going to tell you can be tested. So, my lords, respectfully, not only do we have a basis in the pleadings of both the petitioner and the respondent, particularly first respondent, as I've indicated, where they are talking in paragraph 5, Roman 15. They're saying that this is what happens at the quaternary stage. The Form 12 are then submitted. The Form 12s are then submitted to the returning officer for the presidential election at the National Collation Center. And my lords will observe that paragraph
you want counsel to address it on the paragraph 5, because you see, it appeared, both of them from the evidence were in the strong room.
Yes, my lord.
Yes, and if you look at the witness statement, yeah, there's nothing of this video documentary which yeah,
no, my lord, my lord, yes, but my lord, respectfully,
did he say anything about that?
Yeah, I'm doing a B2. Give me a B2.
No, in the witness statement.
I'm sorry, is your lordship referring to this witness statement? Dr. Professor White gave that evidence under cross-examination after he had referred to a video. He did, the reference to video is in Dr. Professor White's witness statement as well. Yes, my lords, I've just been reminded that it was actually under cross-examination when he was asked about journalists being present in the room. So when PW2 yes, I clearly remember. It was counsel for the first respondent who was cross-examining PW2. And counsel for the first respondent sought to put it to him that there were just people and that he declared the winner of the 7th December 2020 presidential election was Nana Adodanko Akufo, the second respondent. In further answer to paragraphs 5, 6, 7, admits so and so. So, my lords, what I'm suggesting is that this view with the paragraphs in which the petition is raising issues about, starting with that, from paragraph 19 to 21, the pleadings indicate that she was required to act to comply with the Constitution. Then 20, that she acted in flagrant violation of the 1992 Constitution, and that she had a duty to act fairly, reasonably, and candidly. And then in paragraph 23, prior to her making the said declaration, Mrs. Gina Dukwe-Mensah had been notified by agents of certain material errors.
Mr. Chikata, you see, the problem I'm finding with this, your responses is that if you look at the entire petition from paragraph 1 to the end, nowhere did the petitioner plead. Nowhere did the petitioner plead that he even had 2 representatives in the strong room. Nowhere.
Yes, but my lord, the petitioner is not required to plead evidence in respect
that is a fact. No, that is a material fact. That even as a candidate, had 2 representatives in the strong room to take care of his interests. But they can come in now and testify and give evidence as to what they saw or what they did and what happened. Nothing in the petition indicating that even two.
My lord, that is why I indicated to your lordships that in addition to what is in the petition, we have to look at what is in the answer. Because in the answer, the first respondent puts in issue the transparency and all that. The first respondent puts it in issue, as I indicated, and she does that, the first respondent does that explicitly in paragraph 5. Now, the petitioner has to answer the case of the first respondent. The first respondent says in paragraph 5, Roman 15, starting from the beginning, the first respondent says, CI procedure for collating the presidential election results as detailed below. And this is an answer to what the petitioner is saying about acting in disregard of the law and the Constitution and so on. She says, this is the process that I followed. And she says specifically what should happen in the quaternary stage. The petitioner does that. Now, Mr. Chika, agents of the second respondent signed 15 of the regional election results summary sheet. I mean, these are pleadings which the petitioner is obliged to answer through his witnesses. The witnesses of the petitioner must put the facts that are within their knowledge which contradict some of the answers that are provided, particularly answers about what happened in the strong room. And my lords, I was referring to what is clearly provided in Order 11, Rule 7 of CI 47, which in this context I believe, is adopted, which says that subject to this rule and Rule 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for the claim or defense, but not the evidence by which those facts are to be proved. So, for instance, my lords, if you say the first respondent acted in flagrant violation of her responsibilities under the Constitution and under the laws which she operated under, if you make that pleading and the respondent comes and says, no, I acted entirely in compliance, and here's what I did. Here's what I did. Is it possible to cut off what's Can you mute? Actually, it's possible to mute from the control. So, my lords, if our pleading is that she has not acted in compliance, she said, I have acted in compliance, this is what I did, we are obliged to provide testimony that shows that it's not the case. And we don't need to provide the testimony as if we are only limited to the exact words of the pleadings. The exact words of the pleadings that we are put in are that she acted contrary to her responsibilities in respect of the conduct of the election. We say so. And your lordships will respect requiring us to provide the evidence of that cannot be justified, because we have a situation where not only have we pleaded that, but the respondent in answer says, I did so and so, so and so, so and so, including I had agents, and your lordships yourselves asked questions. You had agents all over the country. Your lordships asked those questions, and answers were provided to them. The documents were given to your agents, and so on and so forth. Answers were given to them. And all that has been in evidence, not only without objection, but at the instance of the respondents. All that has been in evidence clearly. So if all that has been in evidence, it cannot possibly be said that that is not an issue in this case. It cannot possibly be said that. Now, my lords, in respect of the paragraph 23 of the pleading of the petition that I referred to earlier, your lordships will note that there is not only a reference to the fact that agents of the petition, and my lord, this is again a pleading which shows that we are referring to our agents. The agents of the petitioner took certain steps. Unless your lordship is wanting us to say agents were appointed by reference to a letter dated so and so and so, but we don't need to do that because that is evidence. But we refer to the fact that the agents of the petitioner, who have also been referred to in the answer, they notified the first respondent's chairperson of certain things. And they go on to say that she refused to accept a letter written to her raising some of those concerns. So the actions of the agents in relation to what happened before the declaration, those actions are part of our pleadings. Now, my lords, I would refer further, and we are still dealing with paragraph 6, which they object to. I will refer further to the answer.
Order, please.
The answer of first respondent in paragraphs 16 and 17. In fact, if I may start from paragraph 15, where the first respondent says, first respondent adds that during the process and as the collation proceeds from state to state, any outstanding objections are addressed, paving the way for the candidates or their agents to sign the forms where they are present and are satisfied with the resolution. Then the first respondent goes on. First respondent adds that prior to the 7th December 2020 presidential election, it put in place a system to deliver a seamless and timely collation of results. First respondent is stating that it put in place a system. And that is the system that the witness is speaking to in paragraph 6. The dedicated fax machines, printers, those are part of the system. They are part of the system that is being referred to. And what the witness is doing is addressing the actual operation of the system from the 7th of December. So, my lords, it cannot possibly be something not born out of the pleadings, because their pleadings talk about, and then in paragraph 17, she says, first respondent says that numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow of the answer of the first respondent. Paragraph 17. He says, numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow for the prompt tallying and collation of the results as expected. My lords, in paragraph 6 of the witness statement, the witness is testifying to what actually happened and testifying in a manner that shows that this claim that is being made in paragraph 17 is actually not correct. It's not an accurate account of what happened in respect of the collation process. The witness's statement is directly contradicting that, because the witness's statement is referring to what happened in regard to the fax machines and their difficulties in operation. And in paragraph 7, which is also being objected to, in paragraph 7, the witness states exactly what happened, different, contradictory to what the first respondent is saying in response to the petition. The witness is saying that they say there were difficulties that were attended to in accordance with the rules. And the witness says, instead of that pre-arranged transmission system for the regional collation sheets to be transmitted to the head office of the Electoral Commission, what happened part of the time was that one of the deputy directors of the EC, that it should have been directors, but it says director. So Dr. Sribo Kweku would from time to time bring into the strong room what was claimed to be a regional collation sheet. How he got that sheet was not disclosed. Now, this is material testimony in response to what is stated in paragraph 17 of the answer of the first respondent. This is very material testimony. Because, my Lord, it really is serious if what this witness is testifying to happened as he's describing, as compared to what is required in CI 127. Because my words will notice CI 127. CI 127. Yeah. So, my words, if there is an issue in this case, if there is an issue, facts about how recollation and issues raised by candidates and agents were attended to, and whether those were done in accordance with the rules governing the election, as they are claiming in paragraph 17, if there is an issue about that, with respect, the witness is entitled to give testimony that enables the court to know that what is being put before us is factually unacceptable. Now, my lords will see also that in paragraph 27 of the answer of the first respondent avers that the presidential declaration form 13, which is a tally of the 16 Form 12s transmitted without the results from the Techiman South constituency, and showing the total votes cast and the total valid votes, shows that second respondent won the 7th December 2020 election. My lords, PW2, the second petitioner's witness, stated in answer to a question from the bench that the form that was put, first of all, he said they never said competitive. That was his answer in earlier cross-examination. Then a question came from the bench where he was shown a so-called Form 13. And the witness stated categorically that that is not Form 13 under CI 127. That is material evidence of what happened. And my lord, that material evidence has gone in without objection. It was in answer to a question from the bench. And then material evidence shows that the first respondent's chairperson did not act in compliance with CI 127. That evidence is there on the record, and your lordships cannot turn a blind eye to a disregard of the Constitution and of the law that has come before you in evidence. Your lordships cannot turn a blind eye. And if evidence is being read, further evidence is being read, which shows that non-compliance, which we have pleaded, we pleaded that there was a non-compliance with statutes and the Constitution and the due process provisions and so on. If further evidence is being read that shows, for instance, that Form 13 is indeed not what is provided for by law, the Constitutional Instrument 127. My lords, that is very material, because your lordships are obliged to ensure that the law is respected, especially when it comes to a matter such as this. And in paragraph 8, in paragraph 8 that is being objected to. That paragraph says, my colleague Dr. Professor Wright and I, and that is a reference to PW1, on many occasions pointed out errors in figures and words on the sheets that were brought in, which ultimately affected totals and assigned results. This sometimes led to EC officials making phone calls on the basis of which they sought to explain and correct some of the things we pointed out. I cannot tell to whom those phone calls were made. I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. There was no transparent process in this regard. My lords, this evidence about
Mr. Chikata, would the court of law have admitted the last paragraph? I cannot tell if the calls were made to EC officials or some people who were also involved in collation process. This is very, very speculative.
No, my lord, it's not speculative.
Somebody is talking on his phone.
You cannot tell.
My goodness.
Yes. But my lord, this is exactly what he said. He cannot tell.
So in evidence, then you must as well leave it.
No, my lord, I carefully. I'm not aware of why the witness cannot say. I cannot tell to whom the calls were made, because he said that they pointed out errors. When they pointed out errors, some phone calls were made. He cannot tell. And he answered by saying there was no transparent process, because essentially a transparent process would have involved making it known who you are calling, because you have to make it known who you are calling so that everybody in the room is clear that your so-called corrections are coming from the right source. So my lords, I fail to see why the witness saying, I cannot tell if the calls were to EC officials or to some other people who who were also involved in collation processes. I cannot see what the objection is. Is the objection being made to some other people who are also involved in collation processes? Because your lordship said this cannot be in a court of law, and I want to. And my lords will see that the paragraph ends with a clear statement: there was no transparent process in this regard. And this again is in the context of paragraph 41 of the first respondent's answer, where the first respondent is saying, in a bid to enhance transparency and public participation in the electoral process, it published all the regional election summary sheets on its website. Your lordships will also see that in paragraph 37 of the first respondent's answer, what they are claiming is that notwithstanding all the resources and training deployed and the facilities put in place, there is a possibility of minor discrepancies as a result of computational and mathematical errors made in the course of the collation of results, but these did not have a material effect on the overall look. That is an allegation that is being made by the first respondent. That allegation cannot just be accepted on its face as being legitimate. That allegation will have to be proved in court by testimony that those computational and mathematical errors did not have a material effect on the on the overall result. That has to be proved. And we have a witness who is coming to court and saying in paragraph 8 that we pointed out errors in figures and words that were brought in, which ultimately affected totals and assigned results.
Please, you understood me. Because you see, if you look at section 63 of the Evidence Act, it says a witness may testify to a matter without proof of personal knowledge if no objection is raised by any party. Now, the court is at a loss whether this could have been raised in evidence. That was all. We were talking of the last bit of the deposition. So that was my worry, because if that evidence is being led in viva voce and it's not objected to, then it will go in. But then, when a legitimate objection is raised, that was my why I wanted to draw the court's attention to that.
Yes, but my lord,
that is under section 63.
Yes, my lord.
No, but you've gone beyond that, so let's proceed.
The evidence has been led under cross-examination.
No, I'm talking of the witness. That's our.
Yes, I cannot. Is it? I cannot tell. Yes, my lord, and that is why I was explaining that the I cannot tell is an account of what happened when they raised objections. They raised an objection. The EC official, and we are talking about officials, these are part of the informal interactions they were having. The EC official then makes a call and then comes back and tells them something. And the witness is saying in his witness statement, I cannot tell who the calls were to. And my lord, is a very honest, it's a very honest acknowledgement.
You don't have any power. But then because there was no transparent process in this regard.
My lord,
the conclusion he seeks to draw.
Yes, because my lord, with respect,
because there was no transparency.
Yes, there was no transparency because Because, my lords, respectfully, if we are dealing with certain figures, and I point out that there are certain errors in the figures that I've been provided with in sheets coming from officials. Those officials are in the room. Those officials are in the room. And they do not have answers. My lords, respectfully, I believe this is an important point. And if I may be allowed to complete my answer, because those questions that they are raising are obviously important enough, and the people in front of them who are EC officials are saying to them, we're calling somebody presumably to give us the information. So they call, and then they come back with certain answers. The witness is saying, I cannot tell who they called, and to the extent that I cannot tell whether those people were even EC officials or not, it does not amount to a transparent process. But that's a legitimate piece of evidence that the witness can give. And if on that basis the witness is saying that there was no transparent process in this regard, well, that is perfectly legitimate. And my lord, in respect of paragraph 8, yes, in respect of that, according to my notes, that is where it was claimed that, I think it's in respect of paragraph 9. Paragraph 9. In respect of paragraph 9, I believe that is where he says that your lordships have already ruled on the question of admissibility or of authenticity. That your lordships have ruled on authenticity, and this is being introduced by the back door. No, my lords, I cannot see how this witnesses paragraph 9. I cannot see how that can be said to relate to the ruling that your lordships made, because you can't, sir.
Proceed, yeah.
I'm sorry. Yes. So in respect of paragraph 9, it is claimed that we are trying to introduce authenticity by the back door. And that is evidently not what we're trying to do, because your ruling on authenticity, your ruling on our application for the production of documents, your ruling did not say that no issues about authenticity can be raised about a document in these proceedings. Your ruling never said that. What this witness is referring to cannot be referable to that ruling. In that ruling, your lordships dealt with specific requests that we had made to the first respondent. Your ruling made reference to specific requests that we had made to first respondent. Here, the witness is speaking to specific documents that they had in the strong room. And the witness says, for instance, when we pointed out problems on the Eastern Regional Collation sheet, another one was subsequently brought in and claimed to be a corrected version. obviously, that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. Now, the witness is making a clear deduction from one set of facts to another set of facts. The witness says, we had a regional collation sheet brought before us. We challenged certain things on that regional collation sheet. Then another one was brought in, supposedly a corrected one. And the witness is saying that obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. Now, this again is clearly material evidence in support of pleadings which are challenging the claim of the first respondent.
My lords, if I, with all due respect, I think counsel should read the whole paragraph, because the sentence that follows. Yes. Very well.
My lords, the paragraph of the witness statement says, obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. The only way to establish the authenticity of that document was for the original to be made available, and a transparent process undertaken in the presence of agents of the candidates for any corrections to be effected. Now, that is the evidence of that witness. And you brought me two documents. You said one is a correction of the other. In relation to the one which was available at the Regional Collation Center, my agent was there, and my agent can give me a report of what happened. In relation to what you are saying is a corrected one, I don't know where it came from. I don't have the original. I don't have a basis to accept it. That is what this witness is pointing out in this paragraph. I will move on after. Yes.
All right.
Net2 Television,
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Tuesday at 2 p.m. to 2:30 p.m. only on Net2 TV.
Net2 Television, beyond the limit.
After many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Committed to being fair and impartial.
Current affairs.
The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves, they're doing it for all of us.
The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Muslim community not to have education.
The show is the sea.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 Television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 Television, beyond the limit. Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 Television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
Allahu Akbar, Allah.
Assalamualaikum warahmatullahi ta'ala wa barakatuh. Jama'a bayan Allah masu kallon mu, ni ne naku Abu Karim. Alhamdulillah lokaci ya kai za mu so maka muku shirye-shirye a nan television Net2 in Allah ya yarda. Nan muna so mu gane wane ne Allah subhanahu wa ta'ala, bayan wannan kuma mu gane menene Qur'ani, bayan wannan kuma muna so mu gane wane ne Annabi Muhammad sallallahu alaihi wasallam, bayan wannan kuma mun duba yaya za a yi so yaranmu su gane Qur'ani, bayan wannan kuma mun kawo muku shani siyasa, bayan wannan kuma mu kawo muku batun abincin gargajiya na zango, yanda za a yi mu gane zama cikin zango, so zamantattayyarmu ya yi kyau cikin zango. Ni ne naku Abu Karim. Wassalamu alaikum.
Watch Asrats every Wednesday 6 p.m. to 7 p.m. Repeats Thursday 6 p.m. to 7 p.m. only on Net2 TV. Net2 Television, beyond the limits.